my absolute honor and privilege to present to you the first of the 3 finalists, and they were not scheduled in any particular order, and it's a team of 3. These are 3 people that I've come to know and love through my association with TOCICO. So I'd like to introduce to you Boaz Ronen, Shimei Pass, and Shemi Karmi. So we'll bring them up, and I'll turn the dice over to them.
Okay, good afternoon. I've been working with Shimon over 30 years, but not with as much time with Shani, only 8 years. And it's a mutual project that we did for the sake of the community. After about 140 implementations of TOC and related techniques and philosophies, usually we devote like 25% of our time for projects for the community, like hospitals, the Ministry of Health, and here, the justice system. So thanks to our friends and colleagues. Thank you. Okay, it's not just in time, it's justice in time. And we're about presenting, applying TOC to law court systems. Okay, here is Edward Bear, Winnie the Pooh, coming downstairs now, bump, 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 on the back of his head, behind Christopher Robin. It is, as far as he knows, the only way of coming downstairs. But sometimes he feels that there really is another way, if only he could stop bumping for a moment and think of it. A.A. Millen. So this is a court system, a typical district court in Israel, 13,000 incoming cases per year, very complex environment, WIP of 15,000 cases, 3 pre-trial meetings per case on the average. We'll see what a pre-trial means later on. 7 evidence meetings per case, 87 types of cases. For each, there is a different procedure, and 20 mega cases. What is a mega case? A case that takes more than 80 judging days. And 4 parties on the average per each case, and 52 judges. Each of them has different kill and specification and a lot of uncertainty. Number of meetings, a number of witnesses, and the length of which witness is taking. And there is a probability to close the case by settlement. So we had the feeling that TOC, current TOC tools cannot cope with this environment. But maybe a good comprehensive model can resolve the problem. What do you think? Just kidding. I think there is a mistake here in this integral. Is this problem specific to Israel? No. We made a literature survey, and we surveyed 22 countries, and we saw that it's amazing. Even though it's different in every country, we have the same problems: increasing demand, increasing operating expenses, most important, long lead time, and diminishing throughput and dissatisfaction of the public. How many of you are satisfied of his or her adjudication system? Don't answer. And why is it so complex? We did a lot of complex projects, like surgery room, operating room, like a lot of very complex service organizations or manufacturing. Why is this more complex than the other? So first of all, there is very little flexibility. Processes cannot be changed without legislation or regulation. You go to a company, and say, you know what, let's differentiate. All those C-type items, let's do it this way and this way. And if the CEO is approving it, within 2 days, you got a new procedure. Here, you have to go to the parliament, change it, go to the CEO of the Ministry of Justice to write new regulations, very difficult. There is judges' autonomy. You cannot force judge to do anything. It's in his or her autonomy. And they are excellent people, really excellent people. They are excellent professionals, and they have a professional culture, not managerial culture. And imagine that 50% of the participants act against the system, because you have two parties. One party wishes to have as long lead time as possible. Imagine in a surgery room, in an operating room, half of the nurses and half of the doctors wish the patient to be dead. This is the situation here. And also, we have the social aspect. My friends, it's not just a word. Justice delayed is justice denied. And there is, in this thing, a very strong social aspect to give justice really on time. And let's see what were the results after using the new concepts. We couldn't use the existing concept. We have to develop new concept. And afterwards, the results were in some pilot implementations. Lead time reduced by 47%. In another implementation, throughput increased by 43%. And I would say more important, when we interviewed the judges, they said that they feel that the quality was improved. And we'll see why. So this is the SOG, very important, but no need to repeat it. Let's go step by step. Step one, identify a giant. We feel that Dr. Goldratt is the giant, and we really appreciate the theory of constraint. Especially, we were using the focusing steps and the DBR mechanism. And SOG2, identify the enormity of the area not addressed by the giant, meaning don't deal with chupchiks. And the challenges are double-fold. First of all, tackling the complexity of law court management, very complex environment. And secondly, tackling the improper functioning of the law court that led poor public trust and high cost of doing business. Because of the long lead times, people say, okay, so I signed the contract. So what? Sue me. It will take you 6 years. That's why it increases the cost of doing business. And it's a matter of public trust. It's a matter of all our safety, of fighting the crime and so on. So we are not dealing with a chupchik. If you go to the government, you have to take care of health, you have to take care of education, and of the adjudication system. So we are dealing with things that are very, very important. And understand the giant solution. Okay, we have here multiple processes. Usually, at the giant solution, he had one bottleneck, one DBR, DBR to reduce sweep and to increase throughput, time buffer in the regular DBR implementation, or in SDBR. We have time buffer to secure bottleneck starvation. We have linear flow per process, homogeneous bottleneck resources, and processes quite known and validated. And we could, having one central planning, we can control all the production floor. What we got here, we got a different process. So the process that I'm giving here as an example in the district court is divided into two parts. First of all, there is a pre-trial sessions. What are the pre-trial sessions? They have to be done very, very quickly, and it takes like 5 minutes, 10 minutes, 15 minutes tops, and the judge tries to get the parties into settlement. And there are all some types of procedures, administrative procedures. So there may be 2, 3, 4, 5 pre-trial meetings. And if they don't settle, they go to the second stage, which is the evidence session. But before the evidence session, we defined a very important stage, which is the planning of the evidence stage. We call it final pretrial session. And here we have evidence sessions. Can be 2 evidence sessions, 10, 12. They may settle in between, and it takes sometimes like 10 or 12 even. And then after the parties did not compromise, did not settle, there is a verdict. But before the verdict, there is a summation. Should it be a written summation? Should it be oral summation? That's one of the questions that we had to cope with. And then there is the verdict, the ruling. So to cut a long story short, some very short pretrial sessions, the final pretrial session where we plan the evidence and which witness is going to be. Then there are the sessions, the summation, and the ruling. And SOG 4, the conceptual difference of the area untouched. First of all, here we have a very rigid environment. Procedures and protocols dictated by law and regulation. You can tell the engineer everything. You tell the engineer, okay, you are a professional, but you should work this way or that way. You cannot tell the judge such a thing. Lack of managerial culture, everything is adjudicated, and 50% of the players act against the system. And let's look at this level of complexity, and this really demands a different approach. Now we are standing on the shoulders of giants and develop new knowledge. The giant said 1 dBr per bottleneck. We developed a new term, a new mechanism called DDBR, double dBr per judge. I'll explain it in 2 minutes. 1 dBr is a frequency dBr, and the other is a release dBr. At the giants, dBr is aimed, among other things, to reduce sweep. And here we have the frequency dBr to reduce open evidence cases. Linear flow per process, multi-iterative flow per process. Makes it 10 times complex than the regular dBr. Homogeneous bottleneck resources, every judge is different from the other judge, needs private scheduling. And we found a very simple a mechanism to do it. And last but not least, central planning and control versus autonomous judges. So let's see, full analysis of the solution. The 5 focusing steps are not sufficient. Hence, we suggested using the 7 focusing steps. This is one thing. The other thing, we had to convert the optimizer approach into a satisficer one. What is an optimizer approach? These terms are taken from Herbert Alexander Simon, the Nobel Prize winner in 1960, and he said, you should be a satisficer. What is a satisficer? One that doesn't look for the optimal, the best solution. He looks for a good enough solution. Like we see with Winnicott, tell us to be good enough parents. Very important, also the satisficers approach. So let's look at the 7 focusing steps rather than the 5 focusing steps. Determine the goal. There was some confusion between the judges, and I'm not sure we have finished it to the end, but we would like judges to provide ruling rather than mitigation. If you go to the court, you want to have some ruling, so some of the judges go this way, some not. And the goal, and I'm quoting Lord Woolf, was the head of the British adjudication system. He said, taking into account the need to allot resources to other cases. So sometimes the judge, he looks at this case as if it were the only case in the world and goes very deeply like an optimizer. And what we would like to show the judges, and we did it through a lot of education and training, is you should look at the system point of view. Don't spend time with over-specification and over-design, just do it. And judges do not look usually for a win-win solution, but rather for compromises and checks and balances. So this is the goal. The goal should be ruling rather than mitigation and look from the global view. Number 2, add measures of performance. Throughput is the number of closed cases. Operating expenses, cost of resources, including judges. Inventory, very simple, number of open cases. It's not enough. The 3 measures are not enough. So we had to put 3 more. One of them is lead time, case cycle time, from the party's standpoint. Quality, the system was not measured by quality. We took it to do the last thing to do, and now we are running a pilot on it. And our measure of quality is a simple one, number of accepted appeals. I put it with a question mark because this is the only thing that wasn't proven yet. All the other, we have the results. And due date performance. Identify the system's constraints. The judges are the bottleneck, no doubt about it. And exploit the system constraints. First of all, we went over a reduction of the ineffective time, of the waste time. It's more than waste, it's ineffective time. And we found out, and the judges approved it by questionnaires, that we have 50% ineffective time. 50. We have in Israel about 650 judges. So imagine if you reduce this waste, this ineffective time by 10%, as if you get another 65 judges. And what about 20%? And the other thing is the strategic gating, which means ADR, alternative dispute resolution, false claims. You have to screen out some of the cases that get into trial. And subordination. In most cases, the subordination worked quite well. In some cases, we had problems with the administration, but once you have a good judge, it's being resolved, no problem at all. And let's see what are for subordination, we have two different processes. In the process, as we said, we had the pretrial case, that all the cases go through the pretrial case, and the effort of the judge, of the bottleneck per case, is 1 hour. At the evidence stage, about 60% compromise, settle. So I'm doing only 40%, but look at the difference here. Instead of 1 hour it's the effort estimation, now I spend 4 working days per case. So we need to make some differential solution. It's not just DBR and go make it. And we had a mandatory comprehensive pretrial session. This is a kickoff meeting. We added to the flow chart a pretrial session. And in this pretrial session, we are preparing the complete kit for the evidence phase. Strategic gating on adversaries. Maybe you can compromise. I'm talking now civil cases. So you do 25-25 on witnesses and content. What is the 25-25 principle? Says take off 25% of the cases, maybe do it in ADR. And the other 25 is just downgrade. Why do you need 4 witnesses? What witness number 4 is for? Okay, the other party, do you agree? Yes, okay, we have only 3 witnesses. How much time witness number 3 can take? We are planning. It was unheard of to plan a court, to plan a case, a trial. So You say 3 hours? What are you going to ask him? The story of his life? There is one thing there. So it takes 1 hour. So do you agree? Yes, we agree. Go ahead. Planning and scheduling witnesses and scheduling oral summation meeting. Very important. We are trying to move the system from written summation into oral summation. Because let's say I heard all the evidences, and now I need the summation of each party. If you take a written summation, the law says 30 days. I haven't seen even one case that we got written summation within 30 days. Always they are asking for a continuation, for more time, so it takes for an average party 3 months, another one 3 months, and it takes like 6 months. After 6 months, the judge doesn't really remember all the details. So he said, okay, on the summer vacation, I write the verdict. Which summer vacation? Maybe next year. And it takes a lot of time to do it. It's a problem. Versus oral summation that takes almost just in time. We'll see it in a moment. And let's see what we are doing here. Daily time. We devoted the day into 2 chunks. Between 8 to 10 a.m., you hear the pre-trial cases. Takes like 10 minutes, so there is no limit. It's not the judge is not a constraint. The sooner he sees the judge, the sooner the case meets a judge, the more the probability raises up to finish it in settlement, in compromise. So you give them excellent service level. And the scheduling is the nearest available slots. Weren't planned. So it was the last meeting, the last pre-trial meeting, and the judge opened his calendar. Of course, he has it on a computer, but to open the calendar, said, okay, fellows, what is your nearest day open in your calendar? And they would say 6 months from now. That's great. Let's have an evidence hearing 6 months from now, end of meeting, meeting after 6 months. Hearing 2 witnesses at that day. Do you have more witnesses? Yes, we do. Do you compromise? No, I'm talking civil cases. Okay, let's open it, and 6 months from now, it can take 3 years or 4 years for 5 meetings. Now we have a frequency DBR saying as follows. Let's see, this is the pre-trial session, the kickoff session. Let's open the calendars only after we reduce the number of witnesses, focus on the important ones, reduce their time, and now what is the first available time? Your Honor, only 6 months from now. Fine with me, so write down. We need 4 meetings and 1 oral meeting, 4 meetings for the evidence, says, and 1 meeting for the oral summation. So it will be 6 months, 6 months plus 1 week, 6 months plus 2 weeks, 6 months plus 3 weeks, and 6 months plus 4 weeks and 5 weeks. And at month number 7.5, we finish it. And I'll give the verdict within 30 days. So you cut 3 years into about 8 months, 9 months. And the first thing is the frequency DBR. What is the frequency DBR? If I schedule the meetings 6 months plus 1 week plus 2 weeks, I can hear only 1 case per day. So if it's 1 week, 5 working days, I have a whip of 5, I have a buffer, I have a whip of 5 cases. If I'll do it 6 months plus 10 days, 6 months plus 20 days, I'll have in my mind 10 cases. So the frequency of the hearing dictates the buffer size. I repeat, the frequency of the hearing dictates the buffer size, and let's see how it is. Before the unplanned hearing, the judge had about 60 cases a lot of bad multitasking. Do you think that a normal person can really remember all the details? So they are writing some memos and so on, but it's very, very difficult. It compromises the quality. Now, in the new system, if it's weekly hearing, I have a whip of 5 cases. I don't need to convince these people here how it affects the quality if you multitask 5 or you multitask 60. Now, let's see how it works. If it's unplanned, as you can see here, so I have, let's say, 18 days. Case A, B, C, D, E, F, G, blah, blah, blah. And then A, B, C. If I have a day-to-day hearing, I hear A, fine. B, 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 fine. What we suggested is to take the weekly hearing A, B, C, D, E in most cases, and let's see in a moment what is the conflict and how do we resolve it using the conflict resolution diagram. But let's see first of all how it works. So if I have an unplanned hearing, no doubt that I have an early start, but unfortunately I have a late finish. Sorry, an early start and a late finish. And the uncertainty risk, what is the uncertainty risk? You have an evidence meeting and the lawyer is sick. We found out that in Israel, the most sick population are lawyers. And their mothers and grandmothers die frequently, sometimes more than 1 time a day. But anyway, if, let's say, for a good reason, that the witness is sick. The witness is sick, I scheduled 1 day, so what am I going to do in this day? So don't worry. Every judge has a buffer of at least 2, 3, or 4 writings. And the writing of a verdict may take from 3 days to a month. So don't worry if it doesn't work and there is a missing evidence hearing, he got enough to do, more than enough to do. These people, I've never seen a profession where the people work almost 18 hours per day. They have computers at home linked to the net of the court, and they work nights, they write verdicts, they prepare it, they work like crazy. So they have a buffer, don't worry. And risk mitigation not required, and so on. So I don't need to waste your time on the unplanned hearing. We had to decide about weekly hearing versus day-to-day hearing. The American system, based on the jury system, takes day-to-day hearing, and we have here some advantages and disadvantages, and we use the conflict resolution diagram, and we solved it through differentiation. By the way, yesterday we heard here that there are not enough tools how to resolve conflicts. We have a great tool. We are willing to share it because we publish it, Shimon and myself, in our 2 books, the General Focused Management book and the Healthcare book. It's called differentiation. To our experience, 60 to 70% of the conflicts are resolved by differentiation. And what is the differentiation? For day-to-day hearing, we'll take the mega cases. We have sometimes mega cases of 150 days. You don't do it weekly. It will end forever. So the day-to-day are devoted to mega files and the others to the weekly hearing. So we resolve this problem in a win-win situation by differentiation. And so this was the frequency drum buffer rope. Why is it double drum buffer rope? Because we have another one, which is the release DBR. The release DBR, how do you release new cases before the pre-trial? And we used, standing on shoulders of giants, we used the buffer management, 3 color zones. So this is it. If if the next available slot for evidence hearing is less than 8 months, which is a huge improvement from what was before, you are on the green zone, it's acceptable. If it's between 8 to 12, it's the yellow, you are late. More than 12 months, unacceptable. And what we were doing, and we had full cooperation with the presidents there of the courts, we go to court floor cleanup, doing overtime, mobilization of judges. And usually, if worse come to worse, the court's vice president or president chokes the release of new cases to the judges. Happened to us once or twice, but it's not seldom. Usually, you have, so as in every place, you have 50% ineffective time, so you have a lot of potential to improve. And the DBR, double drum buffer rope. Evidence buffer according to the hearing frequency, and total buffer size according to the color zone mechanism. But we have to remember, we are not magicians. The necessary condition is that the closing rate is much larger than the opening rate. And we achieve it by reducing the ineffective time. So the first thing that we did there is to take the judges, take all the system to some days of seminars and show how to reduce this waste to create more capacity. Offloading. We have to give the credit for this to the former manager of the court system, and we would like to think that we also have some part on it because the system talks offload. There is a legal aid. The legal aid costs like 20% of the cost of a judge, maybe 15%. It's a young lawyer, comes to serve for 3-4 years, and then goes to his or her way. He can offload about 30% to 40% from the judge's work, things that don't need ruling. And nowadays, we are very proud of it in our system that almost every judge got a legal aid. Almost every judge. Out of 650, I believe that 620 or 630 got their legal aids. It offloads the judge's work. And go back to step 3, no need. The judges are permanent bottlenecks. There were bottlenecks, there will be bottlenecks, and now there are bottlenecks, so no need to make some noise. And the results. In a district court, applying the 7 focusing steps and the DDBR in civil cases, we had an improvement of the evidence. This is the evidence period. The evidence period was reduced by 47%. The evidence hearing is like half of the total time, We didn't take actions on the first one, on the pretrial hearing. We'll see in a moment how to do it. So the total lead time was reduced by 27%. The one that we improved was 47%. We are now in the middle of a pilot to give due dates to the preliminary hearing, to the pre-trial hearings. So the judges know that the pre-trial will not last, I'm just giving an example, more than 8 months. So if the 2 parties come and say, Your Honor, me and my friend, and his friend like he's my friend, me and my friend, we agreed that we need some more time because we are negotiating a settlement. They met 5 minutes before the first time in their lives. But they are, so usually, the notion was that if the 2 parties want a delay, want a continuation, why not? Now they are being measured by due date performance. And the public looks at the time, if a person, a citizen says, I was 6 years in court till my case was resolved, this half a year of continuations is on the judge. So right now, we are doing due date performance, and our first intuition and findings shows that will reduce by 50%, 50, also this stage. And just to give an example from another court, it is a magistrate court. It's the lower court. The district court is higher than the lower court. We had tens of thousands of cases all over the country. And in this magistrate court in Israel, we were dealing with road accident victim compensation cases. And what we see is that the throughput went up 26%. What we were doing there, just one word, applying the complete kit concept. It goes to the judge, the case goes to the judge only if they have all the complete kit, and usually the judge suggested compromise by email, and like 70% of the cases are resolved without need for the parties to come to the court. But sometimes people say, okay, you improved this department. How about the whole department, the tort department, the damage department? So also all the department was improved. Taking into consideration that we did it with less people and more throughput, the total throughput increased by 43%. I just want to show that it works. And the implementation process is the most important thing. Our steering committee was headed by the Chief Justice, the President of the Supreme Court in Israel, the Honorable Judge Dorit Beinish. She retired last month, and she was excellent, devoted a lot of time, a real leader, and the credit goes for her. And the manager of the court system was very effective and efficient. And we had seminars for 96 presidents and vice presidents on TOC and focused management issues like the complete kit concept and so on. In the pilot plant, we had 4 courts, and the steering committee was headed by the presidents of the courts. We had full cooperation. These 4 were real leaders, and we were focusing on a very few improvement topics, very few. Though, you know, there is money on the floor, there is time on the floor, there are cases of the floor, focus. And we gave seminar to the judges, the legal aids, and the administration. It's a one system, and everybody should be geared towards the goal. And there are a lot of peripheral, it's a very difficult project, a lot of peripheral issues there, parties like the Bar Association. We were very scared to meet the Bar Association because we are going to reduce it, and we found what is good for the lawyers. Of course, justice is the best thing for the lawyers, but we showed them that they are going to make much more money if the lead time is going down. So most of them agreed, and at the end of a meeting with a lot of lawyers there in one evening, one lawyer came to us and said, I know that I can make more money, but what took you so long? So they were not rejecting. You have to find what's their interest and work on it. And we had the district attorney and the public defense, all the parties, and we get into a consensus with them. And we had value enhancement teams, and the ownership is their ownership. Though we were very active, I must say, because it was the first time that we did such a project, the ownership is there. And a good advice that we can give you, our friends, if you want to implement it, you have to be very flexible. And every court has its own culture, its own demographic distribution of people and socio-economic, and you have to see the special needs and the culture and the characteristics of each court, and you have to measure it. And when we finished it, we asked ourselves, it's just a beautiful thing, this DDBR. Can we apply it to other cases? And then we said that, as a matter of fact, most service processes comprise of two stages. Stage 1 usually requires a fast response and small efforts, like in the pre-hearings. I need like 1 hour and I resolve 60% of the cases, as opposed to 40% of the cases with 4 days per each. And usually you resolve and screen most of the cases. And stage 2, it's a small amount of entities, small amount of missions come and takes a lot of time. Like, let's take an hospital. What is the percentage of manpower that work in an ER, in an emergency room? No more than 5%. And they screen like 70 to 80%. Only 20% are being hospitalized at the wards. At the wards, you put a lot of effort. There, you schedule the operating room and other wards by DBR. And at first, you give some excess capacity, protective capacity, and it takes an hour, 2 hours, 3 hours, and it works. We got now a project that we're starting to implement it in 2 hospitals in Israel, very large hospitals. One is 1,000 beds, the other is about 500 beds, and we're going to implement it there to see that the DDBR works in other cases. Also in maintenance depots and help desks, stage 1 needs a protective capacity, you need a quick response, and then you can do the other ones by DBR. So this was a real good surprise for us that we came up maybe solving a much more larger concept there. And for the DDBR, should we have protective capacity or should we have a DBR? This one gives you a fast response. This one gives you efficiency and effectiveness. So we also, and this is a great advice, most of our conflicts can be resolved by differentiation. So we differentiate. A little protective capacity is for the first stage, for the first line, for the ER, for the pre-hearing. Then, for the majority of the efforts, do DBR, and you got a win-win situation. PUGI 2, we are going to introduce due date performance. It's in the middle, and we'll see a continuous reduction in the pre-trial case. We are looking for 50%. And PUGI 3, how to do mega cases. We have already the methodology ready. This is really for CCPM. This is really for project management and CCPM to do mega cases. This is not a chupchik. Mega cases are like 30% of the efforts of a typical district court. And I hope that after this, we see that there is another way to overcome. Thank you.
We have 10 minutes for questions. Is there anyone who would like to ask any questions? Okay, here we go.
Quick question. What was the way to show the lawyers that they will make more money with this new system, since they usually bill by the hour?
Are you a lawyer?
No.
Thank you. The way was that usually they get like 70 to 80% upfront. And for the other 20%, are you going to take this case forever? And they call you and they bother you. This is one thing. The other thing is in the car accident. By law, they get either 11, 12, or 13% of the settlement, of the judgment. So you're telling them, look, for another 1% or 2%, you're going to have this burden for all your life. And one lawyer, and there was a debate. I'm not saying there was not a debate. 1% is a lot of money. But one it was very interesting. One lawyer said, okay, Boaz, let me explain it. And he said, look, we are here all lawyers, except for me. And we lawyers, it's like a taxi. You take a taxi, there is a setup cost, and there is a variable cost. And if you are a smart taxi driver, he told this lawyer, you just, whenever a person goes into your taxi, just make it the quickest, and that's it. And they were convinced. No problem there. Yes, please.
There was some obvious quality improvements because they didn't have time, but could you amplify just a little bit more about that?
Sure. What was there, and one of the judges told us, that in the old system, let's say that you have the first hearing today, the second hearing 6 months from now, the third hearing a year from now, and you write the verdict 4 years from now. And the judges said, look, it hurts the quality of the judgment. I don't really remember how the witnesses look like, what they really do. But if I have continuous hearing with oral summation, it takes 4 weeks, 5 weeks, I remember them, I can see them. So we don't have any quantitative result. But Shani interviewed all the judges that were in the pilot, and all of them said, we cannot prove it, but we have the feeling that the judgment the quality was much better. We have here the rationale, the cause and effect. If you have a whip of 60 versus a whip of 5, we know from other industries, and we know from this case, it must be a better one. Now we are going to measure it by this new measure. It's the first time it's being measured in our country. And by the way, when we did the literature survey, all the systems suffer from the same things. So we have to alter, to modify the methods. It's not one by one, but now we are willing to cooperate with everybody in the community here because we feel that we live in a community and we have to support the community with our, I would say, special skills also.
What did you do to convince the judges that this was the way to go?
I think that they had a judge that works 18 hours per day, gave us a chance. We just asked them to come to the seminar. At the first seminar, we had like 20 judges, and it was planned for 30. After the first seminar, there was over demand for these seminars because they saw that we are dealing with simple things. They learned new language, and they had a lot of motivation to reduce their work, to reduce the work. This is their motivation. And when they saw the first results, they are excellent people, and they came to us, and now we have a lot of demand to do it in a family court, in a labor court, and other places. So the main motivation is to reduce the burden. And we tell people they were used for 10, 20 years to do written summation because in some cases they had the erroneous feeling that the whole time, that the desk time, that the branch time is the bottleneck. But it's the judges' time is the bottleneck. And they realize it's not only at the court, but also at home. And they wanted to reduce that time. And they saw we are talking simple tools, simple language. Also, we had a course at the university called The Judge as a Manager. And we give them a lot of managerial issues and topics on top of TOC and focused management, on the soft issues as well. And it's the first time that they learn management. And I think that right now, after 4 years, the system looks different. They speak managerial language.
Was?
Yes.
Here?
Yes, please,
I
Shani.
wanted to add something to the answer that the leadership of the president of each of the courts that we've worked with was one of the main reasons for the success, because whenever we saw that the president was not enough of a leader and did not believe enough in the methods, the implementation was harder. If we had a good cooperation from the president, then it worked better. As we can see in companies, that where there's leadership, the implementation is much easier.
Same everywhere. Yes, please.
Have you been able to analyze or predict the financial impact to the government?
Shani wants to take it as a PhD dissertation. So we are going to do it. I'll let you know when we do it. It's not so difficult, and we have some thoughts, but we are about to do it in the next few months. Thank you. Okay. Thank you very much again. And thank my colleagues that it's a mutual work of all of us.